Welcome to the McNees Litigation Podcast Series. This podcast will address litigation hold letters by James Franklin, attorney at law. Mr. Franklin practices in the litigation group and the transportation, distribution, and logistics group at McNees.
Hello, thank you for joining me for today's video. Today I want to talk about litigation hold letters and 3 considerations that should be going through your mind when you get that letter. Now, if you're not familiar with what a litigation hold letter is, essentially it's a way to put you on notice or your company on notice that you have an obligation to preserve certain documents, certain things, because litigation may ensue. And those things could be electronic or tangible. Now, you may, and your company may have an obligation to preserve those documents and things before you even get that letter. But for today's purpose, I'm going to assume you already have the letter. So what are 3 of the considerations that should be going through your mind when you get that letter? 1, you need to be thinking, I need to take this seriously, okay? You can't ignore it. Why? Because if you do ignore it, or you fail to preserve the proper documents or preserve them properly, there could be grave consequences. Should litigation ensue, you may face economic sanctions. You could face an adverse inference, meaning the jury can assume certain bad facts about your case, or essentially, you could lose the case before it really even begins. 2, you need to think, who needs to see this letter? Who has the documents or things that were requested? And is my system set up to preserve the information? So who needs to see the actual letter? Well, maybe someone like the CEO or CEO level management, maybe outside counsel, maybe in-house counsel. Now, who has the documents or things? So maybe someone in the production level, they don't need to see the letter, but they may have the emails in question. They may have the widgets in question. So they at least need to know of the obligation to preserve them, or you need to go, or someone needs to go and get the emails, the things from them. So that brings me to the other part of, well, is my system set up to identify and preserve those documents, those things? So for example, does my IT system automatically delete emails after 1 year? If so, I may need to stop that, or I may need to find the relevant emails, the emails that have been identified by the other side, and preserve them, so pull them from that destruction process. Am I about to fix the vehicle that was involved in the accident? Well, I may need to put that on hold, or at least give the other side an opportunity to inspect the vehicle first. Again, your attorney can help you with that, which leads me to my 3rd consideration. You need to think, do I need outside help? That may mean an outside vendor, a specialist, someone, let's say, that can come in and help identify the emails, look through your system, identify the emails, and make sure that those are properly secured. They can do that in a very efficient way. Do I need an outside attorney? What can an attorney do for you? Well, they can object to the letter. They can help narrow its scope, help narrow its duration. They can make sure that you preserve the right documents and do so efficiently, with as little intrusion into your daily operations as possible, and they can help make sure that you are as best positioned as possible for litigation should it ensue. So it's key that you really get the right help from the get-go. Here at McNees Wallace Nurick, we regularly assist clients with these very issues, so if you'd like more information on this topic, please contact me using the information provided on the screen. Thank you.